Good afternoon, everybody, and welcome to the Bold Inventor Show. I'm your host, JD Hubener, here with Bold Patents, with a new co-host today. We got David Boslin here with me. David, good afternoon.
How's it going?
And we were talking about this topic today, which is we're going to get to real soon, which is inventing on the job, which is fantastic. And it kind of brings me back to my days when I was an employee at Boeing. I was thinking about this. This came up, and I think it comes up for a lot of people. And so that'll be a great topic. You've got some experience in sort of the beyond IP, right? With privacy thought and, a lot to talk about here in just a little bit. Inventing on the job, I'd love to hear from you. I shared briefly my experience as a Boeing employee. Were you ever an employee?
Oh, yeah. Yeah. Actually, I've got a couple of decades of essentially technology experience, functional matters, dev management, that kind of thing. A lot of different cell phone companies. Actually, there's a lot of them around here.
Yeah.
And one bank that has gone missing now, unfortunately, and a couple other places. So yeah, absolutely. I know what it's like to be not quite the master of your own efforts.
Yeah. Yeah. So, and you listed a few of those. That's almost all of them technical.
Yes.
Nature.
Yeah.
And was that your role as an engineer?
It's interesting that you mentioned that, and not to go on too much of a tangent, but I would suspect that people need to pay a little bit more attention to what they actually do at work, because as you know, patentability is far more broad, I think, than people realize. It's like, it wasn't really a thing, or, it was a process, or I improved some steps on something, or blah, blah, blah. You need to be asking yourself, well, what was the product for that? And is it protectable IP? So I think you don't really have to be that engineer who comes up with some kind of an actual mousetrap. I think there's more work going on in the IP space that needs to be protected by all of the different IP types of things, and including patents. So
yes, totally.
Get advice.
And I think it's also good to know what your role is, or your job description, if you will, kind of putting some bounds on that, as I think it's directly applicable to this analysis that let's just get to it, I think, about who owns an invention.
Yeah.
If you're an employee and you have an invention and it is unrelated, let's say, to what you do on a day-to-day basis, that sort of starts the inquiry. I think it's a relatively easy answer if it lines up directly with what you're doing. If you're hired as a designer, as an engineer, let's say aerospace, let's keep that as an example, and your boss has asked you to solve this problem on the trailing edge to try to get the drag reduced, and now you come up with a cool solution to add some really unique, fittings, a different material to reduce how much flutter you're going to get in the aircraft trailing edge, and you have reduced the drag count. You're amazing, incredible. That's potentially an invention. You'd want to explore perhaps with in-house counsel, if it's a big enough company like Boeing, or if it's small, maybe outside counsel, and talk about whether or not to pursue patent protection. We'll come back to that scenario later, but that's where it's relatively easy in terms of who owns that. It's going to be owned by the employer, okay?
Yeah.
And again, in most every case, and we can get into this, based on your employment agreement. I think it's safe to say most employers, if they've thought it through, they have a clause or clauses that will, in other words, force you, or as the employee, to, as part of the consideration for the work you're doing and the money you're getting paid, to give up any ownership rights in any inventions you make in furtherance of the job. Anything to add to that, David, in terms of that scenario one where it's directly applicable to your work?
I think that's very clear. Even absent employment contract clauses, it's it's kind of a layup to say, well, you're using our machines, you were doing what you were doing at our direction, you are an employee, and it's pretty established law that the IP you produce under those circumstances, you aren't the owner of.
Yes, so that is sort of this scenario one, and it's pretty open and closed. The only perhaps that I'm thinking of way out of that is if you're a non-employee contractor, and you were clear, perhaps in the contract, that what you're doing is going to be owned by you, right? That would have to be specified, wouldn't it? There's no sort of...
First of all, please do that. If you're going to do work for somebody else, please put that kind of at the top that says, I own anything.
Right.
Even if you're producing it specifically for them to use, allow them a non-exclusive, global, permanent license, whatever, but you still own it, right? So
Right.
whatever the language needs to be like, get counsel to help you craft that, but please do that.
Yep.
The other piece of it is that we're starting to talk about works made for hire, right?
Right.
As a concept. And a work made for hire, a lot of people wave their hands and go, wow, I was hired, and so it's a work made for hire. Absolutely not the case, especially in copyright law, where the Copyright Office provides these circulars that you should go look up because they're amazing. And it's there's actually a really short list of topics that are eligible to be works made for hire.
Oh.
Otherwise, if you produced it, it's yours, and that's the end of it, right? So there are some complexities. If you are not a direct employee, make sure you understand the circumstances and things like that. It's a 20-minute call with a knowledgeable attorney to make sure you're on the right path. Don't mess around with it.
Don't mess around. Yeah, if you're a contractor and you want to make sure you have ownership on things you create for someone else, hire an attorney to make sure that contract is going to be bulletproof. That kind of sounds like the answer. Do not do it on your own. There is a lot of weirdness, grayness, attorneyness that I think needs to be inserted to make sure that you're going to have, the ownership that you want. And anyway, cool. I mean, that's a great conversation in itself. Now let's talk about sort of an invention that is unrelated, directly related to what you do. Let's lay out. I don't know if we have a citation, but right. You almost listed off some of these analysis, right? 3 or 4 different factors, right? So I believe one of them, I'll do one, you do the next one, is are you using the employer's machines, tools, equipment, right? I believe that's one of the factors.
Right.
So even if it's an invention outside of what you do, if you're using the employee's computer, equipment, manufacturing tools, even their phone, even your laptop, so the more you use a company's employer's assets, even if it's unrelated, that would be a factor that goes toward the employer owning it.
Yeah.
What's another factor, or do you want to?
Sure. What right does the employer have to guide how you do your work? Right. Mm-hmm. You have an objective, but can the employer say you need to do it this way or you need to do it that way? As an independent contractor, it might be like, you wanted XYZ. That's what I'm going to give you. How I do it's up to me. Right. So that would be more of a contractor perspective. Whereas if the employer has the right to say how you're going to do some things, that's more like an employee, right? So it's not always, even regardless of whether or not there's an employment contract per se, and you got hired and you get days off and all of that. If you're really rolled in underneath what they're trying to do and they can direct how you do it, that's also another really driving factor as to whether or not you're actually an employee-employer situation for the purposes of who owns IP.
Yep. Awesome. What other factor might you consider in this analysis? So we talked about the big ones, right? Is it related to the job? We talked that, and then the
equipment, office space, and then how much control they have over what you're doing. There are some other things, but they kind of move into whether or not the employer is responsible for torts and were you operating in the furtherance of the duties that your employer provided you and things like that. Those are the things that are coming to mind. But
yeah.
I saw your email this morning and it just started to make me think, well, gosh, as an employee, what control do I have as to whether or not a patent is pursued? Right. Is it, are you going to prosecute this patent or not? And then after you said, well, I thought, gosh, what if I don't want my name? You said attribution is required. Yeah. Right. The company owns it, but attribution is required. What if I don't want attribution?
Interesting. Let's lay that out. You and I had some correspondence. Let me just lay the foundation. So the question is, if you're on the job and there's a potentially patentable invention, as the inventor, can you pursue it, even though your employer has no intentions to pursue it? And I think the answer is yes. 99% sure. I'm very confident. I don't see why not. As an inventor, you can file it. The major downside is the employer is not going to foot the bill. You, the individual inventor, will have to pay for hiring legal counsel, paying for the filing fees to do that independently. And there may be some other layers there too, right? So very interesting here, David. I think because I may be able to backtrack my answer. Within the employment agreement, there is confidentiality. There are trade secrets.
Yeah.
And so what might be patentable could be trade secret information. Therefore, when you file, by you filing a patent application, even though it's a provisional, let's say, if you follow that path forward and file a non-provisional, and you don't, and you do allow it to publish, you have now potentially fallen it toward misappropriating a trade secret. I think taking steps toward that.
Yeah.
How interesting. Okay, so I may actually reconsider my answer.
I think the answer is still probably yes, but could you get in trouble for doing it? Is also probably yes.
Yeah, totally. And then you're like, okay, well, yeah, so privacy, let's say as the inventor, I am 99.9% sure. I'm 100% sure. The inventor must be named. The inventor a human being must be named. You may not file an anonymous patent. There's no such thing as anonymous inventor that I'm aware of. So an inventor must be named, and therefore it will be published. You can wait all the way until it becomes granted. You can file a non-publication request if you want to remain right in this sort of, while it's pending. And so if you do that, you give up the ability to secure rights overseas. So this privacy question, which I think is maybe the origin of this, you really have no desire. You don't want to be named as the inventor for whatever reason. Right.
Yeah. Like say I invented a better mousetrap, but it only catches ducks. Company loves it. I think it's retarded, and I don't want to have my name associated with it at all. And they're like, well, we have to put your name on it. It's like, please don't do that. So
well, I think we should even push some hot button topics. I mean, let's say in pharmaceuticals, or maybe it's something having to do with reproductive medicines, or where it's very controversial, right? Or maybe even let's go Oppenheimer, right? I've developed a nuclear weapon, and I by no means want my name attached to it, but I've been told to create something. So that would be quite controversial. Or a case where you may not want to have your name attached to something such like that. You're sort of
maybe you pulled together a really fantastic anesthetic that you thought, oh, this is going to be wonderful. Fentanyl is garbage, and this is going to be super excellent. And then the company wants to sell it to the states as part of a 3-drug execution package. And you're like, that's not me, man. But that's how they're going to sell it and market it, and your name's all over it. So yeah, that's entirely possible. Which that's what got me thinking, how much leverage as the inventor do I really have? Because what made me think of that is you said an inventor must be named. It's like, well, if there was just one person, can I halt this or come up with a different name? So it made me think about rights of publicity and rights of privacy. And there really isn't federal law specifically for either of those so much. There's analogs sort of in the Lanham Act for trademarks. I can't advertise a product and falsely make it look like you're associated with that product or endorse that product in some way. So that's a bit of a right of publicity, right? It's not privacy so much. It's the fact that you are you. You own your signature, your image, your likeness, your persona, all of that stuff. And this is becoming so much more important in this age of influencers. Everybody's third cousin is an influencer in some social media platform, right? I'm being silly, but it's true. People make really good money off of this, and it's important. And the thing that is of value is that publicity that you literally own. About half of the states have right of publicity laws, so protect it in some way. About half. The other half, most of them sort of protect it, but through rights of privacy. Right, the right of privacy is a little bit older. It's got Supreme Court backing. About 60 years back, Griswold v. I don't remember what, that established rights of privacy. Penumbra off of the personal rights amendments, like first, third, fourth, fifth, ninth, those things have personal rights. And so
So
you're right.
Image and likeness standards, or is that more for famous?
This is just, hey, I have a right to be a private individual,
Okay.
search and seizure, things like that. I can go into my house and stay there. Nobody has a right to say, oh, I want to see David. It's like, nah, piss off, I'm staying here. So that's where that comes from. Whereas the right of publicity is almost like, take who I am and I have the right to monetize that. Just like anything I create, it's who I am, I can monetize that. So wouldn't it be nice to have a federal law that helps us unpack that instead of, this mosaic of laws? It's like,
right.
Don't get me started on the Digital Millennium Copyright Act and the fact that we don't have something like that for trademarks. But
yes, I think I'd like to just talk about what we would say to do to the the hypothetical client, how to protect an invention that you've invented. As yes, you're an employee, but you wanted to protect it and keep it separately. I would say to that inventor, hey, just make sure you're off the clock. Make sure you're not on the job using their equipment, tools. Make sure it's totally unrelated to what you're doing, what you're paid for, what your job description says, and make sure that there's, those are the big ones. I would say there's no control, right? There's no evidence or ability for the employer to say, hey, we directed you or asked you to do this for us. Mm-hmm. Is that about right? Is that kind of the big one?
It's pretty close, I would say. However, in reality, the time we spend during the day tends to be where we're thinking and our ideas come from and whatnot. So at some point, it becomes a slippery slope, tangential kind of thing. It's like, if I follow this thought back, work was involved somehow. You just want to separate yourself as much as you can from that. And so like JD, like you were saying, it's like, don't do it at work. Go and get a secondhand used laptop and just noodle the stuff out on that, not your company laptop. And then, depending on your relationship with the people you work with or work for, like you say, some sort of freedom to operate. It's like, I have this other thing that I'm working on separately, it has nothing to do with work. And if you can get something that says, knock yourself out, I mean, that's probably the best.
At Boeing, I decided to do one, even though it was very unrelated to my work as an engineer. I did what's called a conflicts of interest form, or to get a waiver. Hey, I'm going to start with a separate entity, separate business for my law firm. Obviously, I have no intentions. It doesn't seem to, or does not conflict with my work. Here's what I'm doing. And I would say 99 out of 100 times, they're going to say, yep, looks great, thumbs up. So being above board, honest, hey, I've developed this product totally separately on my own. I have plans to commercialize this separately. Does that sound good?
Right? And you brought up trade secret, and a trade secret only just in the last few years became a federally supportable law. That was all done by the states and whatnot. And now that employment contracts are limiting, the employment contracts can't so much say you can't go work for company X, or you agree to spend 3 years not doing your job after you leave us, kind of nonsense. So the companies can't restrict how their intellectual property leaves the company by keeping people from working.
Correct. Right. Non-competes are on the way out.
So trade secret law and how that's handled is becoming more and more and more important. So what that means is that for you also can't just wait 3 years and then go nuts. You really have to understand what your obligation is to any sort of previous employer with respect to their intellectual property, or what might be their intellectual property. Like you were saying, they decided not to get a patent. They're just going to go the trade secret route, right? And we'll keep it forever. We don't think it's reverse engineerable, Right. So why would we do a patent?
Yeah, I think it's in this age where we're getting more and more data, right? Whether to collect it, to make all these LLMs, for all the AIs, you have to be even more on purpose about very clearly documenting, this is where we're keeping this very special information. We're only giving it to a very small amount of employees, and this is how we're going to deal with it when you come and when you exit. So all that just takes all the additional hoops that will help you with enforcing a case for misappropriation. Yeah,
I'd throw out, this is more for employers than employees, but I'd throw out a plug for Tangibly.
Oh, Tangibly.
Tangibly, yeah.
Okay. Yeah.
Go to tangibly.com. They just do a wonderful job with this interface between patenting and trade secret. And then once you got these, what are your trade secrets? Number one, who knows what they are? Number two, right? I got to work with a contractor, so that person's got to be NDA'd and all of these different things, right? So like you were pointing out, you really, as an employer or any sort of an entity, you've got to be very deliberate about keeping track of these things, because that deliberation is what will come into court later when you're trying to show that somebody misappropriated your IP.
Totally.